Governor Scott has less than a week to sign or veto legislation that would overhaul Florida's alimony laws. So people on both sides of this issue, as you can see here, crammed into a waiting room yesterday trying to get opponents to change their position on the bill. The bill would end permanent alimony and promote equal time for child custody in divorce cases. Now, the governor has received thousands of calls from people for and against the measure. Joining me now is Beth Luna with Luna Law Firm. Good morning to you. Thank you for being here.
Good morning.
I appreciate it. Let's start with the alimony component first.
Okay.
If you could, for those people maybe who are not divorced, as an example, have never been through this, I mean, I've always heard that alimony is based, obviously, on income and length of marriage. How is what's being proposed different from what currently exists?
Well, currently we look at factors. There's no formula. So the new alimony bill would give a formula that would allow us to calculate the amount and the duration that alimony would be. So that gives some predictability and consistency across the state in how we determine alimony, whereas right now it's factors. So a judge in this county could make a decision that might be different from a judge in a separate county.
But that said, then, does it take the ability, it removes the ability of the judge to look at all of these factors and make determinations based on case by case, as opposed to basically saying, kind of a little bit like the sentencing guidelines that we see in criminal court, well, okay, it's between this, and that's what you got.
Well, there's still exceptions in the new alimony bill that would allow the judges to make some exceptions if people are able to prove those. And so that is still within this bill, but it does give some consistency. If we have a formula, it gives a starting point for the courts and for the judges, and even for litigants who are not using attorneys. They would be able to maybe easier go to a judge and say, I'm asking for alimony, and here's an amount that we believe it should be based on the formula.
And maybe save them some money so they don't have to get an attorney.
That's true.
Okay, but that said, there's also this, which is getting a lot of heated debate, is ending alimony, because, you know, there are situations where someone was given alimony, basically permanent alimony. They are in a new relationship. They are engaged but decide not to get married on purpose because then the check from the ex-husband stops.
Well, there is no permanent alimony provision in the current alimony bill as it's proposed. Again, people would be able to argue factors if there were exceptions, maybe where you have a spouse who has been at home with the kids and is unable to go back and get a job because they are too old and they can't go back and get education, or they've got a disability or a health issue. That is all still within this as an exception. Again, it may create more litigation because someone would have to argue those exception factors in order to get that.
Could you prove then to a judge, hey, you know, my ex-wife has been in this relationship for a long time and is purposely not getting married because she wants me to continue to pay alimony? Could you do that then under this new suggestion?
Yes.
This new proposal, rather?
There's a basis to modify that looks at cohabitation and support from another individual. That's currently also part of the law, but it's in this bill as well.
So now, obviously, because it is hard enough getting a divorce, I would imagine, but then when you have children involved, there's some language differences here, which sounds like legalese, quite frankly, to me, because there was an overhaul about 3 years ago, and now this bill would, this proposal would change the words used, that you'd have to start with the premise that that the children would get equal sharing time. How is that different from what we already have, and well, who's affected by it, obviously?
Right now, what we have is parents should have a continuing relationship with their children and a frequent one. And so when we look at that, we're starting from the idea that the state is not saying any type of time sharing is better over another. And they're using the word premise over presumption, which is what it was before, that the premise of equal time sharing is now available in the state. You know, really, it's about what's best for the children and not what's best for the parents. And every family is unique. Every child is unique. We need to do what's really in the best interest of families when it comes to determining where time sharing is going to be.
Especially if there's a domestic violence situation where a parent, a mother, as an example, maybe was battered and is worried about, you know, now having to go into court, and the court automatically thinks, okay, we got to look at 50-50 time share.
That is one concern, is that with that bill, that domestic violence victims may be less likely to leave because they're worried about leaving a child 50% of the time with a batterer. There are also concerns with the alimony bill when we look at domestic violence victims in terms of, we know sometimes they don't leave because of finances, jobs, and daycare. So if they're worried about that, we may see them leaving less. I mean, obviously, until the bill passes and we see the results of it, we don't know. But those are some concerns with it.
Thank you very much for the explanation. We do appreciate it. And the governor, we're told, has yet to even see this bill, but has a week now to make a decision as to whether or not it will be vetoed. Melanie?